on the scheduled discussion that we have on labor and employment under the Biden administration, past and future. And we're really blessed today to have join us Yona Rozen, Associate General Counsel with AFL-CIO. And Yona, welcome to the Houston LERA Chapter. And thank you for being willing to share your thoughts with us on things that we have seen and things that we might continue to look for under the Biden administration as it relates to labor management, relations, and employment. And with that, Yona, I'll turn it over to you.
Hey, thank you so much. So first off, it is very nice to see lots of faces I recognize back from my 31 plus years in Texas. So it's good to be back, even if it's via Zoom. In thinking about doing this presentation, I've tried to, okay, why am I not? Hang on just 1 minute. Okay. I've tried to come up with a way. There's so much to cover that there's no way that we can cover it all today, but I thought that I would try to sort of pull together some of the things that have already happened and ideas about what's going to happen over the course of the next year or so. And particularly, I'm really focusing on the NLRB, the Department of Labor, and the EEOC. I think the first thing about labor and employment under the Biden administration, and particularly coming at it from my perspective now, having been at the AFL-CIO for the last 7 years, is this is the most, as he says himself, but it's really borne out in the actions. Biden is the most union-friendly president that certainly in my lifetime. And I'm getting pretty old these days, so I've been through a lot of presidents. Just to give you some examples, I mean, we're going to talk about what he did the very first day of his term, but at the time that the Amazon election was pending and about to take place, the ballot, I guess just before the ballots went out in Bessemer, Alabama, he made a statement, which I don't think any other president has done, in support of employees having the right to choose to be represented by a union. Just this week, with respect to Kellogg's announcement that they were intending to permanently replace strikers who have been striking against Kellogg's, the president made a statement that you can see on Twitter, basically how horrified he was about the concept of permanently replacing employees who are exercising their right to strike. So it's really a different administration in so many respects. And this was clear day one of the Biden administration at the NLRB. He asked, this was the very first day when he was inaugurated on January, was it 21st, I think? He asked the then General Counsel, Peter Robb, to resign. When Robb refused to resign, he was terminated at the end of the day. His Deputy General Counsel, Alice Stock, then was the acting GC, and Biden in turn asked her to resign. And when she refused, she was terminated. So I think Alice Stock has the shortest period of time being acting general counsel. I think she came in on the 20th and went out on the 21st. And this was, there's a difference between board members and general counsels. The general counsel, Peter Robb's term was supposed to go through mid-November. But in fact, over the years, people have concluded that while the general counsel may be appointed for a particular term, it's not the same thing as board members who serve for the entire period of their term. And that the general counsel serves at the pleasure of the president. This was discussed during the Reagan administration, and now Chief Justice Roberts was in the White House counsel's office and opined that General Counsel Bill Lubbers, who was general counsel at the time, served at the pleasure of the president. But in the end, Reagan didn't remove Lubbers, although there is documented evidence that there was clear discussion, and Roberts said, yes, in fact, the president could replace the general counsel. Peter Orr was named as acting general counsel. He had been the regional director in Region 3. And while he was acting general counsel, he rescinded certain general counsel memoranda that Rob had put out previously, and also issued, that's in GC 2102 and GC 2103 general counsel memorandums. He issued a statement about intention to really enforce protected concerted activity. So subsequently, Jennifer Abruzzo was nominated and then confirmed as general counsel. This just gives you the dates of when. So Rob was general counsel from November 17, 2017 to 1/20/2021. Alice's Stock, as I told you, was probably one of the shortest acting general counsels for one day. And then Peter Sung was named a couple days later as the acting general counsel. And then Jennifer Abruzzo. And Jennifer Abruzzo is a long-term agency employee who held a number of roles, including deputy general counsel under Dick Griffin's tenure as general counsel. And also when Dick Griffin left, before Peter Robb was appointed, she was acting general counsel. So she has a great deal of agency experience. And then day one of the Biden administration, he also assigned member McFerrin, who was the only Democrat at the time on the board, the NLRB board. He assigned her to the position of chair, replacing the then chair, now member, John Ring. And day one, they issued executive orders preventing and combating discrimination on the basis of gender identity and sexual orientation. They, early on, not on the first day, but there were a swath of executive orders covering protecting federal workforce, covering revocation of some of the orders that executive orders Trump had issued, ensuring the future is made in all of America by all of America's workers, so protecting Buy America, and an executive order protecting worker health and safety. So very early on, they came in ready to go and moved forward with a lot of executive orders, as well as a large number of nominations for the Department of Labor, for the NLRB, for the EEOC, and for other agencies. Here, as we noted earlier, Jennifer Abruzzo was nominated, and she was confirmed. I think she was actually confirmed on July 22nd, 2021. And she almost immediately, like within days of her confirmation, she issued a mandatory submission to advice, which general counsels generally do. This was like in very early August. You can go look at GC 2104, and you see just a huge list of types of cases and issues that she is looking forward to presenting, things that she wants to change. She's also indicated an intention to escalate the use of 10J, which is the injunctive relief, to seek full remedies in cases, including, for example, cases she's trying to argue to have the most effective kinds of remedies under the existing laws. So to deal with situations like somebody had to go into their 401k because they were terminated due to an unfair labor practice, that they should be able to be restored and have the damages, the cost, the penalties that they incurred by taking money out of their 401k would be part of the remedy. So very, very expansive view of what remedies would be available. And then shortly thereafter, on May 27th, There were two. So at the time that Biden took the oath of office on inauguration, there were 3 Republicans and 1 Democratic board member. McFerrin was the only Democrat. You had Ring, you had Kaplan, and you had Emanuel. Gwen Wilcox was nominated on May 27th. There had been a vacancy at the board for a long period of time since Mark Pierce had left, and she was nominated to fill that vacancy, and she was confirmed on July 28th, 2021. Gwen has an extensive experience with a union side firm in New York, had tremendous amount of experience, has been practiced, and had also worked for the board in the early part of her career. And then David Prouty was nominated on June 22nd to fill the slot that was going to come open when member Emanuel's term expired in August of 2021. And he was also confirmed on July 28th, 2021. Funny story about Dave. He actually was, Emanuel's term expired on August 27th, and he was sworn in the next day on Saturday, I think, August 28th. And then later on, he had to be re-sworn in because it turned out that the president had not signed the papers at the time that he was sworn in. So he had to be re-sworn in a few weeks later when the NLRB discovered this issue. So what's happened so far at the NLRB? Nothing really earth-shattering, but the board has, one of the things about changes at the NLRB, so Jennifer Abruzzo is looking for all sorts of cases that will be vehicles to change the law in various ways. But those cases, they have to go with, unless they're engaging in regulatory, issuing proposed regulations and getting comments, they have to go with the cases that come before them. So just like an arbitrator might want to change something, but you have to have the case in front of you to make the ruling. Well, same thing with the board. So there are some cases in the pipeline that could be vehicles for changing certain aspects, but there really hasn't been a ton of sort of really massively law changing cases so far. But they just issued the regulatory agenda twice a year. The agencies issue a regulatory agenda. It's announced in the fall and in the spring. And in the fall regulatory agenda, which just issued on December 10th, they have announced that they are going to engage in rulemaking on the joint employer issue, which is, of course, is a very hotly contested issue, which the Rob board had worked on regulations, but also tried to change via case adjudication. Of course, there were problems with case adjudication because of Emanuel having a conflict of interest. So that's an issue that's been going back and forth, but there is an indication in the current regulatory agenda that they will be addressing that issue and intend to issue a proposed regulation. The General Counsel has issued, as I said, a series of memoranda where she has indicated issues that she wants to bring before the board. And also, if you follow the NLRB Twitter account, you'll see that she tweets about cases that she wants to bring. The board itself has issued requests for briefing on certain cases that are pending before them on a number of important issues. So we anticipate that in the next few months to a year, there will be board decisions on some of those issues. And of course, waiting in the wings is the PRO Act, which would massively change the National Labor Relations Act in a number of respects. It's been passed by the House, not enough votes at this point in the Senate if you're going to have 60 votes, but it is included as a part of the current Build Back Better, which is pending right now and being discussed right now, which is part of if it's done that way, the penalties for imposing greater penalties for current ULP violations is the part of the PRO Act that is in Build Back Better. So depending on what is happens over the next few weeks, that is a possibility, something that you could see come into effect through Build Back Better. At the EEOC, switching gears now to the EEOC, Biden also fired the EEOC GC under a similar argument. That was Sharon Fast Gustafson, and her term was supposed to run through 2023. Peter Robb's term was only going to run through November, so we now are past the time that Peter Robb's term would have expired in any case. And Biden terminated her. He again asked her to resign early. She refused. And then he terminated her on March 5th, 2021. And he's still not nominated anyone for that position. There is an acting general counsel who is a long-term agency employee. The EEOC, the chair and the members, are currently, there's still a Republican majority at the EEOC, and there will be until Janet Dillon's term expires in July of 2022. So these are the people who currently serve as chair. Dillon had been chair under Trump. When Biden came in, he made Charlotte Burrows the chair. And Jocelyn Samuels, the vice chair. Those are the two Democrats. So the other members are former chair Dillon, Keith Sonderling, and Andrea Lucas. And you can see that there's going to be at least until July of 2022 before the EEOC will change. So the EEOC has been relatively quiet. Again, because there's not a majority and there's not a permanent GC yet. There's no rulemaking announced in the fall regulatory agenda, but the one thing that they have done a great deal of work on, and today they just announced a further change in the guidance regarding how to deal with how COVID-19 issues intersect with disability issues. So I would commend you to look at that if that's something you deal with. Department of Labor. So of course we have Marty Walsh, who is the first Secretary of Labor who came out of a labor union. He had a career with LIUNA before he was the mayor of Boston. There are many appointments that were made at the Department of Labor, some of whom have been confirmed, some of whom are still waiting for confirmation, who come out of strong labor or workers' rights backgrounds. And here I've named a few of them. Doug Parker was confirmed. There had not been an OSHA director at the Department of Labor for most of, in fact, maybe even all of Trump's administration. So now there is an OSHA director. Of course, David Weil has been renominated to again be the director of the Wage and Hour Division at the Department of Labor, but not yet confirmed. So we'll have to wait and see. You keep seeing stories. They've done some things, they've worked on some things, but there's sort of like people are sort of still anticipating and waiting to see what's going to come next, because really not that much has been done. And people haven't been in, and the confirmations took quite a while. There's been so much going on in the Senate and the House that it's been very difficult to schedule some of these confirmation votes. I do a lot of work on judicial appointments as well, and they're trying to push them through, but just scheduling floor time for votes in the Senate is very, very difficult these days because there's so many other issues that are pending. So the Department of Labor early on was involved in quite a lot of activity that was involved. I had to look the names of the statutes up because I couldn't even remember the COVID relief provisions that were passed at the beginning. The first was Families First Coronavirus Response Act, which had, of course, special leave provisions and special medical coverage, paid medical leave provisions to cover parents whose children were not in school, special COVID-related unemployment insurance provisions, and also the American Rescue Plan Act. So the Department of Labor had responsibilities with respect to all of those, and was pretty involved in doing that. And then also, of course, there was a big push from the beginning of the administration to get out the emergency temporary standards regarding COVID, which finally issued, and then of course are tied up in litigation. The OSHA is doing other rulemaking as well in the regulatory agenda. They've announced rulemaking, particularly with respect to workers' exposure to heat, infectious disease, so not, like COVID related rulemaking, so that for on a non-emergency basis, because the ETS is only in effect for a certain period of time. They immediately and early on withdrew and rescinded, and I can't remember, one of the independent contractor regulation they withdrew, I think, in the joint employer rule, they rescinded. They were at a different point in moving forward to implementation. And so one was rescinded and one was withdrawn, and I get confused which one was which. But in the, when I just spoke earlier about the fall regulatory agenda, they did announce an intent to update the overtime rule. You remember that their Obama administration had updated the overtime rule and increased the top, at what point of salary level it was going to be required to pay overtime. And then the Trump administration attacked that and subsequently issued a rule that had set it at a lower level. But the Biden Department of Labor is intending to propose and hopefully implement an updated, modernized overtime rule, an updated tipped employees rule, and modernized Davis-Bacon. I wanted to mention a couple of other things that are going on in the administration that I think are important and interesting. So the White House has a task force on worker organizing and empowerment, which is chaired by Vice President Harris and with Department of Labor Secretary Marty Walsh. The task force includes the heads of various different executive orders, and they're tasked to identify executive branch policies, practices, and programs that could be used consistent with applicable law to promote my administration's policy of support for worker power, worker organizing, and collective bargaining. And so far, the task force has focused its recommendations on federal workers, but its final report has not been released yet. The NLRB, the Department of Labor, and the EEOC have engaged in some interagency initiatives, one particularly focusing on protecting workers from retaliation for exercising their statutory rights. And also they have engaged in similar collaborative work with respect to immigration issues as they tie into labor and employment issues. This is just, as I said, the OSHA ETS, all that effort going into getting it issued, and immediately went into litigation. And there, you may have read the stories where there were lawsuits filed, I think in every circuit, possibly maybe not one circuit, but multiple circuits. And it was finally the Sixth Circuit won the multi-district litigation exercise to determine where the case would go forward. So I think, one wonders, given the fact that it's a temporary standard, whether the litigation will even be completed before the standard expires. And that's why I said the Department of Labor is looking into issuing something with respect to infectious diseases such as COVID that would be a permanent rather than a temporary standard. So I think I went through that very quickly. I think we have a little bit of time for questions, or we can talk about other things that I didn't put in the slides. I guess I would say it's been an very interesting first year. This doesn't relate to the agencies, but when you look at sort of the amount of organizing activity that's going on, the positive views that the opinion polls say unions, particularly among younger folks, are enjoying. and the strike activity. So we had Strike October, Strikes Giving, and now Strikesmas, I think. But the idea being that there has been a lot of strike activity. So it promises to be an even more interesting year 2 of the Biden administration. And then we'll see what happens with the elections in 2022. So happy to answer any questions. Let me see.
Yona, there's one question on what is the status of FMCS appointments?
Yeah, I know. I meant to look this up and I can't remember.
Yeah, I'll be glad to take that one if you like.
Yeah, can you take it? Because I know that somebody was nominated. I'm trying now to rack my brain about who.
Yeah. So Javier Ramirez has been nominated to be the next director of the FMCS. For those of you more familiar with the FMCS, Gary Hattal has been the deputy director acting in the capacity of the director. I have to be careful how I say that because it's important to get his title right based on the statute. And so Gary has now announced his retirement at the end of this month. And so my expectation would be that if Javier is not confirmed by then, which he likely won't be, just because of timing, that he will then be the acting director nominee, which would be his title. And so he has been nominated. And to those of you not familiar with Javier, he comes from within the FMCS staff. He was a commissioner and has recently been in charge of our Department of Strategic Initiatives and has come up with some really forward-looking ideas and areas for the FMCS, including the whole transition to 100% virtual that we had to do basically overnight here almost 2 years ago. And Javier, along with Josh Flax, who some of you have become familiar with from our prior LERA meetings, Javier and Josh really spearheaded that effort with their staffs on how we were going to continue to serve the public from a remote environment. And so Javier Ramirez officially has been nominated and awaiting confirmation.
Thanks, Walter. I have a question for Yona. Could you just talk a little bit about the role of AFL-CIO and how does a union become affiliated with AFL-CIO?
Okay, sure. Well, the AFL-CIO is, and this is labor always talks, when journalists will always say like the biggest union in America, and we're not really a union. We are an affiliation of unions. And so we, I think that both Rich Trumka and now Liz Schuler, the current president, after Rich died, have worked really hard at trying to find roles that the AFL-CIO can serve the affiliates. So we do a lot of coordinating, we do a lot of coming in and supporting work that the affiliates are doing. The way, we just actually had a new affiliation, which is a rather small union, but it is the women's soccer players. I don't remember exactly what their correct name is, I should, but they just affiliated recently. So, basically they come forward and the AFL-CIO we have the national AFL-CIO, which is who I work for. And then we have subordinate bodies. So each state has a federation, which is similarly made up of various, the state affiliates of the affiliates, as well as people. So other unions who may not be affiliated can be part of the state federations through solidarity charters. So for example, a lot of Teamsters locals are affiliated with this central labor councils or with the state feds, SEIU locals, some of the other unions that are not part of the AFL-CIO. I guess the way so I'm trying to remember about what actually happened, but when the Women's Soccer Association affiliated, but basically they approach the AFL-CIO and indicate that they want to be an affiliate. And there's negotiations and they set it up. There are requirements that affiliates, based on their members, the number of members, dues paying members they have, they pay per capita into the state feds and the the national AFL-CIO, and that's basically how we get our funding, which is really then why we are trying to do what they think is most important and what would be most helpful to them, because we really are basically an umbrella organization that serves the needs of the affiliates. And we do a lot of policy, legislation work, election work, mobilization work, support, strategic research for organizing that's done by the affiliates, those kinds of things. So it's been very interesting. It's very different from what I did when I was practicing law, representing locals and individuals in Dallas, Texas, but it's been a lot of fun.
Do you do a lot of training?
We do a lot of training. There is a tremendous amount of training that's done on, so there's training that's done for a whole series of things. There's training that's done in terms of new information that's coming out, new laws. There's training that's done for new officers in local unions in order to, so that they can work, serve in the way that they need to and be aware of their fiduciary obligations, aware of their legal obligations, how to run a local, how to run the finances of a local, how to do the reporting that they have to do. So those kinds of training. There's training with respect to, organizing. There's an organizing institute that is operated out of the AFL-CIO that works. There's organizing training that's done for strategic researchers from various affiliates to help them with the things that are needed in order to do a good job of organizing. So a lot of training.
Thank you.
Yeah, sure.
Hey, Mickey, in the absence of another question, I'd like to add a little bit on the federal side, if I could. And Yona, feel free to step in here, agree, disagree, or just add additional fabric.
Okay. Someone help
some of the things we're
take my, how do I stop sharing? I can't seem to find because I was going to take it down so that.
It's down. We're back to just seeing the speaker.
Okay,
so,
good.
So
good.
you've accomplished that.
Okay. I don't know how I did, but good. All right.
Yeah.
Sorry.
So some of the things that we're seeing at the FMCS when it comes to the federal side or federal employee bargaining, for those familiar, former President Trump had quite a few executive orders that he issued giving direction to different departments within the government on how they should bargain, how long they should bargain, whether or not they should discuss permissive subjects of bargaining, or if they should only discuss mandatory subjects of bargaining, how what is commonly termed official time was to be handled, which is time that a union official spends basically on the clock servicing the employees that they represent, and he put out executive orders limiting that based on membership. And so there were quite a few of those out there, many of which were kind of making their way through the courts as to whether or not he was able to do that. But all of them, I think, when his presidency ended and President Biden was sworn in, may have been at various stages of appeal, but were in effect basically. And so one of the first things that President Biden did is he unwound many, if not all, of those executive orders, and gave some direction back to the government departments that if they were in the process of bargaining an agreement with their union, that they were given a wider berth in terms of what they could and what they should and what they would talk about that permissive subjects of bargaining would come back into play and it wouldn't be limited to mandatory subjects. He unwound the bargaining timelines that President Trump put in place. President Trump, by executive order, had imposed a finite amount of time that he allowed agencies to bargain, at which point they were to declare an impasse. And then President Biden went one step further and said, if you have closed agreements that have been reached with your unions that contain some of these subjects, you are to approach your unions and offer to reopen those agreements and to bargain over those subjects. And so as a result of that, we're starting as an agency to see more requests for assistance from these groups. President Biden has seated, I think and I think you covered it in your presentation, Yona, he seated his panelists for the Federal Service Impasse Panel. There were vacancies there when he came on board, and the impasse panel runs the term of the then sitting president. And so he has now put 10 members in there. I think the statute calls for at least 6. But he's put 10 members in there in the impasse panel. And the reason that's significant is if you're not familiar with federal bargaining process, federal employees that are represented, by unions.
Sweet. Thank you.
Somebody needs to mute if they could. Employees that are represented by federal unions bargain with their employer. And then if they're unable to reach an agreement, then they or their employer have the right to file with the Federal Service Impasse Panel, declaring an impasse and requesting the assistance, at which point they're required to go through some neutral mediation process. More typically than not, it is the services of the FMCS that are employed, and the FMCS engages, attempts to help those parties reach an agreement. If the parties are unable to reach an agreement with the assistance of the FMCS, then the impasse panel holds the rights to basically dictate the terms of a new agreement. And so that's why that is significant. But those are some of the things that we're seeing as changes within the federal sector. And we're seeing more requests from federal employers and the unions representing their employees to get involved in their negotiations. So, Yona, anything you want to add there?
No, thank you, because I did sort of miss federal sector in a big way in what I covered for the most part. So I think that's really good that you added it. And then the question I had for you, Walter, is, the NLRB has just put out a request for comments about continuation or non-continuation of the virtual R case hearings and C case hearings that they've been doing, during COVID. And I was just curious, at the FMCS, I know that as you mentioned, you really switched to virtual mediations and bargaining. And I'm wondering, as people are coming out, hopefully at some point coming out of COVID, and even as things are reopening a little, is there still, are people finding that was an effective way to do negotiations and mediation, or are they moving back to in-person, or what is happening that you've seen?
So I can certainly speak to my area of responsibility, which is Southeast Texas, Southwest Louisiana, and Mid Louisiana, and I can speak a little bit more broadly as to where we are from the agency. From an agency perspective, we still are by and large operating in a remote environment. We do have a process based on requests that come in for us to get involved in a face-to-face environment. We have a process where we escalate that through our leadership, our direct line leadership, and basically we're not conducting in-person mediation unless the circumstances warrant it, based on a very high threshold of criteria, including certainly but not limited to imminent and expected work stoppage of significant proportions and/or a healthcare contract. and what our agency is looking for is that all other virtual mediation and alternatives have been exhausted prior to having a mediator go back face to face. I think we as an agency have served the parties well. I know I've worked many cases over the last couple of years in a remote environment where the parties have reached an agreement, and my coworkers around the country have done the same. It's not the same as being there.
Mm-hmm.
We don't purport that it is. We don't pretend that it is. But I think we're doing the best with what we have. And I will tell you, from what I'm seeing more and more of now is parties going back face to face. And then when they employ our services, we're joining them via video feed,
Mm-hmm.
which creates an even more interesting dynamic when you have individuals in a room with each other, and then the mediator is there via video feed. And so that creates some challenges of its own, but we work hard to get through that. And we've also employed some new technologies to help us with those cases. So, we're continuing to move forward. We're hoping to get back sooner than later, but we're going to continue to be diligent in trying to help the parties in the environment that we're in.
I have a question for both of you.
Okay.
Assume you were at the head of each of your agencies or organizations. What would be the one change, legislation that you feel would have the biggest impact in your area? And we'll start with Yona.
Okay, well, I think the PRO Act, from the point of view of private employees and their ability to organize, I think, the organizing drives that we've seen recently, it show you how hard it is under current standards for employees who want to be represented to successfully navigate an organizing campaign. So I think the PRO Act, passage of the PRO Act, is critically important. So I think that would be a game changer.
Okay. Walter?
Yeah, so, and this is, one person's opinion, but I think from my perspective, it would really be twofold. One is the use of ADR tools. We're obviously big believers in ADR tools when it comes to administration of collective bargaining agreements, not only the negotiation of collective bargaining agreements, but also the administration of collective bargaining agreements, grievance procedure, things like that. Because I believe that the tone can be set, intended or unintended, for the upcoming bargaining. How I get along with you or don't get along with you, whether I'm representing the labor side or the management side, and how effectively and how well we do that can have the unintended consequence of affecting how we're going to bargain another collective bargaining agreement. And so I think, anything that could be put out that would more strongly encourage folks to use those ADR principles would ultimately benefit in what we believe our key role is, which is the protection of interstate commerce when it comes to bargaining, collective bargaining agreements, and would help parties get to an agreement sooner and perhaps with less pain. And then the second piece is probably when and where we get involved, right? I think we are properly suited, that we don't have enforcement authority, and that's way okay. And I think that works well the way it's set up. I think practically what happens is we get involved too late in the game with the parties in many cases, because they're the time we get the call. And they're entrenched, and it becomes more difficult for us to do our jobs. And so what we're seeing with some parties now is they're involving us from early on in the process, from day one of bargaining. And I think those parties would tell you they're seeing the benefit of that. So, maybe perhaps when we get involved, how we get involved. I think we're properly suited not to have enforcement authority. We're not arbitrators, and don't want to be, but we're about helping parties get a deal, and anything we can do to help grease the skids on that would be helpful.
Well, on behalf of, I think it's 1 o'clock or so. So on behalf of Houston LERA, Yona, thank you very much for taking the time.
Thank you for
And
inviting me.
Walter, thank you for being on our panel as well. I do have one other thing. I just wanted to thank Walter for his tenure as president of Houston LERA. During that tenure, our membership doubled just about. So thank you for all your hard work, Walter. And I know that you're going to continue to be on the board and contribute significantly. And Yona, thank you again.
Thank you. Nice to see everyone.
Thank you, Yona. Thanks, Mickey.
Bye, everyone.